Well, legislation has been prepared for Congress that would change the bankruptcy venue rules. The basic idea of the bill is to make access to bankruptcy courts easier for disaffected creditors of a bankrupt debtor. And this is a big deal for farmers. Joining us now is Professor of Agricultural Law and Taxation at the Washburn University School of Law, Roger McEowen. Thanks so much for joining us, Roger. And let's start with a recap of the current law for filing bankruptcy and how the new legislation will differ.
Well, good morning, Christina, and you're right. This is a very important issue for farmers, particularly in the Midwest and the Great Plains. But under current law, a business has certain options concerning where it can file bankruptcy, and those places include the state in which they're organized, of course, and the location where the business has significant business assets or conducts business, or in some certain situations, and this is a big issue, where the parent company or an affiliate of the company has filed bankruptcy, then all the subsidiaries can go to that same jurisdiction and file bankruptcy there.
Okay, now, Roger, why does tightening venue matter? Do you have any examples?
Well, because the looseness of the rules right now that allow a company to basically forum shop where they file bankruptcy can create a pretty tough situation for a farmer that has a claim against the bankrupt company if they have to travel far from their farming operation to participate in the bankruptcy. And yes, a big example of this a number of years ago, some people will remember the Verasun bankruptcy. Verasun had 24 of its subsidiaries that filed for Chapter 11 bankruptcy along with the parent corporation that's headquartered in Sioux Falls, South Dakota. But they filed bankruptcy in Delaware. And so all of the farmers that were delivering corn to a Verasun elevator on corn contracts for production of ethanol, they had to travel all the way to Delaware, over 1,000 miles away for some of those, pack up their lawyers, pay their lawyers to go there, and then participate in a bankruptcy proceeding on the East Coast with a bankruptcy judge and East Coast lawyers that aren't necessarily familiar with state grain elevator laws and certain rules that apply in agriculture bankruptcy settings. And that can be a very frustrating and expensive experience for a farmer.
Oh, I'm sure. Now, what's the goal of the Bankruptcy Venue Reform Act of 2017, and how do you see it impacting farmers moving forward?
Yeah, that's a great question. I think the goal of it is to drastically reduce the ability of companies to forum shop bankruptcies by denying access to justice for creditors of companies that choose to file their bankruptcies primarily either in the Southern District of New York or Delaware, when the issue involves a company that impacts farmers in the Midwest or in the Great Plains state and where this company does not have any operations on the East Coast. And so it's a really big deal. This is pending legislation that's going to be introduced into the Senate, we hope, by the end of this week so they can get in the omnibus bill, but if not, in early January. It was previously defeated. The Obama administration did not support it, but it is coming back, and I think it has a head of steam this time.
All right. Well, we appreciate your guidance as always. Roger McEowen with the Washburn University School of Law, thank you so much for joining us.